If you look at the FIR, one, state as a complainant. Contents of the FIR are incredibly vague. A JIT is constituted, FIA notices. These notices are not even served properly as per the proper process. Everything, the manner in which the FIA has acted is unlawful under the procedures that are written down in the Prevention of Electronic Crimes Act, in the rules, and obviously what the constitutional safeguards. The FIR against Asad Toor has been registered under sections 9, 10, and 24 of the Prevention of Electronic Crimes Act. And there's a lot of discourse right now about how disinformation is actionable under the law. But if you look at the FIR, one, state as a complainant, and so it is a member of the FIA who has filed this report. Secondly, the contents of the FIR are incredibly vague, and they pertain to malicious or obnoxious, explicit campaign. These are the words that have been used against the judiciary or public servants, and none of these they don't count as offenses under the Prevention of Electronic Crimes Act. Section 9 specifically pertains to glorification of an offense, and that has to be in relation to terrorism or a person convicted of a crime. Similarly, cyber terrorism has to be read in connection with other sections, which are 6, 7, and 8, which pertain to unauthorized access to information or copying of information, and they are completely unrelated. It also deals with interfaith, sectarian, hate, and none of this is made out either. And section 24 is about cyber stalking. And cyber stalking, obviously, if you're trying to attempt to contact somebody or you've used somebody's picture in a particular context. So none of these are made out. Again, the FIR is vague, no specific content, just links to the YouTube channel or X or Twitter profile that has been provided, and just the manner in which this entire exercise took place. A JIT is constituted, FIA notices issued. These notices are in circulation on social media. These notices are not even served properly as per the proper process. No copy of complaint, no details are accompany these notices. So despite the fact that Asad voluntarily appeared at the FIA office and he was detained for 8 hours, still the FIA sent another notice, and when he approached the court, and the Islamabad High Court specifically issued instructions that the FIA must act in accordance with the law and that they must not harass him, he was arrested when he again appeared for a second time for questioning. And so the entire manner in which this was conducted is not in accordance with the law. When he was arrested, no formal charge appeared until the next morning when he was produced in court, not in the presence of his lawyer. So again, this very clandestine manner where you first issue notices, even though somebody is complying, joining the investigation, you go ahead, proceed with an FIR, and then you don't even give the contents of that FIR comes about while you're already in their custody. So the entire process has been inversed. And this is not in accordance with the law. A lot of people are detracting and obfuscating, saying, you know, this is about, there have to be limits on freedom of speech. But the primary issue here is how the executive and the law enforcement have arbitrarily and unlawfully exercised their powers. And that is something that the courts must also focus on. Then the issue of legality. The problem is that now it's going to be, the process is going to be used as punishment. So once somebody is already under arrest, now you have to go through the motions of the law, where right now he's been remanded into FIA's custody for 5 days until there's judicial custody, which is going to be 5 days later. If that happens, he can't apply for bail. And after that, to apply for quashment of the cases or through the trial court, once a challan is presented, all of these things take time. And he's already been through this cycle previously as well, and scores of people have been through this cycle. So the onus then transfers onto them, that as the accused, you're treated as a guilty party, not innocent until proven guilty, and you have to then establish your innocence by going through the motions of this law, which is the problem, that the procedure is abused, the law is abused, and nobody questions the very fundamentals of whether this FIR can stand or not, whether these notices could stand or not. All of this is taken at face value. It is accepted as though they are legal just because a law is being cited. But everything, the manner in which the FIA has acted, is unlawful under the procedures that are written down in the Prevention of Electronic Crimes Act, in the rules, and obviously what the constitutional safeguards. All of these things have been flouted, and none of this has been of the primary concern, and none of this has been factored into creating this binary between free speech and limited speech. The second issue is that disinformation, yes, it's an issue, and as we've seen in the past few days, there have been incidents that, bringing religion into it, that obviously can create a life-threatening situation. However, what you need to do with disinformation, especially of this kind, first and foremost, is to put out that corrective. Because what disinformation does is create a perception, and those perceptions can be incredibly dangerous, especially when people act on them. So you need to get the right information out immediately at the same time. So instead of what we do is coercive measures, punitive measures, everything needs legislation and everything requires criminalization and arrest. This is not an appropriate approach. We are signatories to the ICCPR. We have various restrictions in Article 19, but just to vaguely say that Article 19 exceptions apply, when and how something is criminalized, there's a high standard, and where criticism for any branch of government cannot be criminalized in this manner. And there's a lot of jurisprudence on this, especially the Human Rights Council as well. So what we cannot justify is arbitrary, unlawful state action just because there's another issue that you're obfuscating it with, which is disinformation. And secondly, to counter disinformation, you also have to use other tools, which is putting out correct information, countering it, creating that narrative, correcting the perception. Where legal accountability comes in, you still have to act in a lawful manner. And we have already, the report that we have put out in collaboration with the clinic basically discusses what is problematic in the law. Overcriminalization, giving regulators overbroad powers, discretion, all of these things are not okay. So when you're framing the law, that's also important, that it's not discretionary. It doesn't lead to arbitrary exercise of powers. There have to be limits. When you are restricting a right, it has to be necessary, it has to be proportionate. And with criminalization of speech, these are overbroad, unnecessary restrictions, unreasonable restrictions. And this is why if they were to be, and the problem is that we don't even put them to these tests, whether they are necessary and proportionate and follow lawful means. So just because a law exists doesn't mean the law is okay. And you also have to read the law in conjunction with other fundamental rights, and especially here with other sorts of jurisprudence. So just to say it happens elsewhere in the world, what you have to look at is precisely, and law has to be framed with specificity. So what is the precise thing or harm that you are looking to regulate or address? And here, the problem is that we go with an elephant's foot approach, and we want to criminalize and over-criminalize everything. We already have scores of laws that are used and misused to this effect. So the law has to be precise, it has to be specific, it cannot be arbitrary. And that's the problem with how we've approached regulation, whether it's to tackle with disinformation, which we've attempted to do through amendments to the PEMRA laws. There's an e-safety bill which was approved previously. There were amendments to PECA which were also prepared. And then, of course, the application of PECA the way we see it. You can't just have these siren cries saying this has happened and now it's actionable. Whether it is actionable under the law or not, and how is it actionable, those things matter. And in this context, this is something that is being overlooked.